WNAV 8:52, and time for our tips with Byrd and Byrd. And joining us today is attorney Jessica Estes from the law offices of Byrd and Byrd. Good morning, Jessica.
Good morning, Bill. How are you?
I'm fine. How about yourself?
I'm doing well.
Okay. Hey, what is a joint account, and what are the legal ramifications of having a joint account with someone?
A joint account is an account where two or more persons have an ownership interest in that account. The account can be held either as tenants in common or in joint tenancy. If the account is held as tenants in common, each person whose name is on that account has an equal interest in the money held in the account. When one person dies, their respective share will pass through probate and be distributed to their beneficiaries. Whereas if the account is held as a joint tenancy, when one person dies, the account automatically belongs to the surviving account holders and is not distributed to the deceased individual's beneficiaries. This may or may not be that person's intent. Most accounts are held in joint tenancy. Also, if you have a joint account, the other joint owners have the legal right to that money, and the money in that account could be subject to their creditors, lawsuits, bankruptcy, or divorce.
Well, is it okay to have a joint account with your spouse?
Yes, it is absolutely okay to have a joint account with your spouse, and it is actually quite common.
Well, is it recommended to have a joint account with other individuals like your children?
Generally, it is not a good idea to have a joint account with individuals other than your spouse because of your exposure to liability and other unintended consequences. For example, if dad and son have a joint bank account that has $100,000 of dad's hard-earned money, and son, while driving, gets into an accident, injures the other driver, and then gets sued, all of dad's $100,000 is subject to recovery in a lawsuit by the injured driver, all because son was the joint owner on the account. It does not matter that son never contributed to the account.
Okay, now, Jessica, can I put my son or daughter on my account to have access to my money to take care of me when I get older?
You can, but beware. We call this the blank check story. So oftentimes, parents put a child on a bank account to have access to the money to take care of the parent as they age. This is not always the best idea because your child can use any or all of the money in the account for any purpose, not just to take care of you. The child on the account has essentially a blank check to legally spend your money on whatever they desire.
Well, what if I own an account jointly with my son or daughter? Can my daughter-in-law or son-in-law access my money?
This is a very common question, and the legal answer is maybe. Generally, people do not want their in-laws to have any access to their money. But if, again, dad and son own a joint account, and son is in an auto accident and can no longer manage his finances, who do you think his power of attorney is? Most likely it's going to be his wife or dad's daughter-in-law. So because son is a joint owner on the account, son's wife, acting as his power of attorney, could access the money in that bank account. And this is probably not what dad had intended.
Okay, now, if joint accounts are not advisable, how do you give someone access to your money so they can use it to take care of you?
The best method is using a power of attorney. By using a power of attorney, the child or other individual has no legal interest in the money in the account, and it is not considered his or her money. It would still be considered yours. The power of attorney ensures that your agent may access the account only for your benefit, not theirs, and thus there's no exposure to child's lawsuits, creditors, bankruptcy, or divorce. And if you want to make sure your account is available to your child when you pass away, you can name him or her as your pay-on-death beneficiary so the money will bypass the probate process and not be subject to the claims of your creditors.
Okay, now, if any of our listeners have additional questions or want to learn more about proper titling of assets, how do they contact you, Jessica?
I can be reached at 301-464-7448 or on our website at www.byrdandbyrd.com. That's BYRDANDBYRD.com. And as a reminder, I host informal workshops on the second Monday of each month. The next one will be July 14th from 5:30 to 7 p.m. at our offices in Bowie. The workshop's free, but space is limited to 10 people, so you should call and reserve your seat. There are also light refreshments served. We do these workshops, like I said, on the second Monday of every month, so if you can't make the July 14th date, then we have workshops planned for August 11th and September 8th as well. So join us next week for more tips.
Well, thank you very much, Jessica. Pleasure having you on board.
Thanks, Bill.
Okay, Byrd and Byrd, LLC, attorneys at law, elder law lawyers with offices in Bowie and Prince Frederick, Maryland. Not just good lawyers, good counsel.